Before the first case is even called, this courtroom is already telling us something important. This is not a quiet docket. This is a morning packed with sentencing decisions, sobriety court debates, missed testing windows, and a judge who is absolutely not in the mood for excuses. We're in Michigan's 14A District Court, presided over by Judge Simpson, and pay close attention because how he handles accountability today sends a loud message. You'll see first-time offenders asking for leniency, defendants juggling work, school, and sobriety requirements, and others skating dangerously close to incarceration because of one recurring issue: compliance. Miss a test? Be late too many times? The judge makes it clear, intention doesn't outweigh obligation in his courtroom. There are moments of humor, moments of tension, and moments where everything shifts instantly, especially when family members are pulled into the conversation. Watch closely how Judge Simpson balances rehabilitation with hard consequences, and notice the difference between people who take ownership and those who try to explain their way out. The real question is this: at what point does the court stop believing your intentions and start enforcing consequences? Stay with us, because this docket answers that question more than once.
Likewise, does not believe the conflict exists, but if one does, we also wait.
The court, for its part, also does not believe there's a conflict either in the Michigan court rules or the cases decided thereelunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the People versus Jason, is it Elk? It's you. Oh, come on up. Who's your attorney? Mr. Goldman. He stepped out. All right. Well, I'll pass it. Okay. Court does call the case of People versus Reginald Sims.
They also stepped out.
Good morning. Okay, so I'll pass that one too. Third time's a charm. Court calls the case People versus Chanel Griffin. Miss Pate is here, and I think your client.
Suspender, I believe, on behalf of Miss Griffin. Oh, can you please state your name for the record, ma'am?
I'm here.
State your name.
Chanel Griffin.
Thank you, Your Honor. Me and Ms. Griffin had the opportunity to review the PSI. We only have one update. I believe since the report has been written, Ms. Griffin states to me she has taken care of her outstanding warrants. Outside of that, we have no corrections to the report, and we would respectfully request the court adopt the probation's recommendation for the sentence.
All right. Ms. Griffin, anything you want to tell the court before I impose that? Question mark.
Ms. Griffin, was there anything you wanted to say before the judge imposed sentence?
Oh, I'm sorry. No, sir. I didn't. Oh, maybe you guys hear me. I'm sorry.
Sentence of the court: $480 fines and costs, 93 days in jail, suspended. When can you pay the fines and costs, ma'am?
I can have it paid off in, I say, like 90 days.
She say 90?
I believe
90.
so, Your Honor.
90?
Yeah.
Like
90?
90?
90, yeah.
Well, you're gonna have to do it a little bit sooner than that. I'll give you to February 28th, 2026.
Okay.
All right. Thank you.
Thank you so much.
Thank you, Your Honor. Thank you, Ms. Griffin.
Thank you.
Court calls the case People versus Ethan Ryans.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Ryans, who appears on Zoom. Sir, please state your full name for the court.
Good morning, Ethan Ryans.
Go ahead.
Thank you, Your Honor. Today's date and time set for sentencing. We have had the opportunity to review both the assessment as well as the recommendation from probation, which I have had the opportunity to review with Mr. Ryans. He does just have one request as to the sentencing recommendation. We're asking if the court would consider not imposing the twice weekly or in the alternate, consider possibly only once weekly of the AA classes. Mr. Ryans does state to me that he continues his enrollment in school. It's my understanding that he's taking 16 credit hours as well as working during this time to earn.
This moment may seem routine, but it's actually a textbook example of how probation-based sentencing works in district court. Miss Griffin receives suspended jail time, meaning the 93 days hang over her head, but won't be served unless she violates the court's order. The $480 in fines and costs may sound manageable, but notice how Judge Simpson immediately tightens the payment timeline. Courts don't just care if you pay, they care when. This case sets the tone early. Cooperation matters, preparation matters, and credibility matters. The court acknowledged she cleared her outstanding warrants, which absolutely helped her outcome. So let me ask you, should judges be more flexible with payment deadlines, or is firm structure the only way accountability works? Keep that thought, because financial obligations come up again with much higher stakes.
Earn money. He does have some concerns about both keeping up his schooling with his job if he is attending 2 of those per week. To my understanding, he has been completely compliant on his bond, and this is the first offense of something of this nature. Outside of that request, Your Honor, we would ask the court to adopt probation's recommendation.
Sir, is there anything you want to tell me before I impose sentence?
No, sir. Pretty much as my attorney has stated, I've tried my best to stay compliant with my tether. I have quit alcohol earlier this year in April, and I plan on keeping that track. So,
Where are you in school?
Washtenaw Community.
What are you going to be when you grow up?
Currently, I'm studying business administration and looking to transfer over to Michigan State with fall 2027 enrollment.
To where?
Michigan State. That's where I'm looking to transfer to for management.
Why? For God's sakes, why?
A lot of people feel like I'm betraying you, Mish, but honestly, I feel like the competitiveness.
That might get worse. Why are you going to transfer into state?
I feel like the environment is just a little bit better for me. The competitiveness with
Have
U of
you
M.
ever been there?
No, I took a tour there back when I was 17.
You took a tour at 17, and
Yes,
it took
sir.
forever, didn't it? None of the buildings are together. The whole place is like spread out.
Yeah, the entire city is the campus.
Yeah. So you really want to be a Spartan?
Yes, sir.
Well, we might have to change this sentence. All right, young man. Well, I wish you all of the best, and I'm just teasing with you. The court does acknowledge this is not a serious misdemeanor as defined by statute. However, believes there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of intensive outpatient treatment, attendance at AA meetings, and abstinence from all intoxicants. The court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. It is therefore the sentence of the court that you are placed on 18 months probation. You are to pay $855 fines and costs, $100 prosecution recovery costs, $100 police agency recovery costs, and $540 probation oversight fees. When can you pay that?
Give me about 48 hours, please.
48 hours?
Yes, sir.
Oh, I like you. All right. I'll tell you what, pay it by the 26th, okay?
Yes, sir.
Has the Spartan ever told me yes, sir? No. Yeah, he's going to be the first.
I have.
There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete an intensive outpatient substance abuse program, including all recommended aftercare with status reports to probation. You're to attend 1 AA meeting per week with monthly verification to probation. You're to provide proof of victims' impact panel attendance to probation. You continue the scram tether an additional 30 days in lieu of 5 days in jail. All order 93 days in jail that is suspended. Thank you.
Thank you.
Thank you, Your Honor.
And sincerely, young man, good luck to you.
I appreciate you. Thank you.
Thank you, Mr. Ryans.
Thank you.
Court does call the case. People versus Brendan Williams.
Hello.
There he is. Assistant Public Defender Natalie Pate with on behalf of Mr. Brendan Williams. Sir, can you please state your full name for the court?
Brendan John Williams.
Thank you. Your Honor, today's the day and time set for sentencing. Likewise, I had the opportunity to review both the assessment as well as the recommendation from probation. As to the recommendation, we are respectfully requesting that the court adopt it.
Sir, is there anything Ms. Blair?
Your Honor, Teresa Clare on behalf of probation, I would just like to make the court aware, I did receive Mr. Williams's victims impact panel attendance. Also, so the court is aware, Mr. Williams is starting on probation with me on another matter. This case is not a violation of that case. It happens prior to being sentenced.
Got it. All right, Mr. Williams, anything you want to tell me before I impose sentence?
No, thanks.
Okay. Court does acknowledge this is not a serious misdemeanor as defined by statute. However, it does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of substance abuse and mental health treatment. Therefore, the court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. So for the sentence of the court, I'm going to place you on 24 months probation. You're to pay $1,055 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs. I will waive the probation oversight fees. When can you get that paid, young man?
I was wondering if I can work out a payment plan with my probation officer.
Is he already on a payment plan?
Yes, Your Honor.
All right. There'll be a payment plan as directed by probation. Understand that?
Yep.
This exchange is fascinating because this is where the court leans heavily into rehabilitation rather than punishment. Mr. Ryan presents as compliant, respectful, and forward-looking. He's in school full-time, working, sober, and communicating clearly. And notice how Judge Simpson responds, even teasing him about Michigan State, because engagement like this tells the court something critical. This defendant is reachable. But don't mistake the friendly tone for leniency. The sentence is still serious. 18 months probation, over $1,600 in combined costs, random testing, treatment, AA meetings, and tether time. This is accountability with a roadmap. Here's the real question for you. Should first-time offenders who show genuine effort be given this level of structure instead of jail? Or does that risk being too forgiving? Because what happens later today shows exactly where the court draws the line.
There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete a dual diagnosis programming, including all recommended aftercare, with status reports to probation. You're to provide proof of the victim's impact panel attendance to probation, which is completed. I'll order 365 days in jail, credit 42. The balance is suspended. Right. Thank you, sir.
Thank you.
Thanks, Mr. Williams.
What?
Can you do your recall?
You're messing up my holiday.
I know, I apologize.
What? No, you stay here. I'm going to go home. You want me to recall both? Is everybody here now? Because everybody like bolted before I came in.
We're ready on that.
I know. I see you. You see that? I was asking you and he just decided to talk. Court calls the case, People versus Jason Eckel. Should have heard, I know you're ready. You should have heard what your client said. I don't know why he's not here. It was horrible.
Good morning, Your Honor. Robert Goldman, P81222, here on behalf and alongside Jason Eckel, President of the court this morning. Mr. Eckel, would you please say your full name for the record?
Jason Michael Eckel.
All right. Thank you. All right. What are we doing today?
Your Honor, this is a date and time set for a sentencing hearing in this matter. I've had an opportunity to speak with the probation department in this case. Your Honor, a a plea was conditioned on Mr. Eckel being admitted into sobriety court. Mr. Eckel did screen with this court's probation department. Ultimately, on Friday, we were advised that he was not accepted into this court's probation sobriety court program. However, having spoken with Ms. Pilara, it is the understanding of the parties that we would be asking for an adjournment today for purposes of screening with the either 15th District Court or another Washtenaw County District Court for purposes of admission. We do think that Mr. Eckel is a good candidate and can be admitted. So for that reason, we are still seeking admission, as we believe that the ultimate benefit of the program warrants seeking an adjournment at this time.
Is that correct, Ms. Pilara?
Yes, Your Honor. I did learn on Friday from the 14A sobriety court that he was not accepted. I did speak with counsel and indicated to him that there is 2 other options in the county that he could try to get into their program. I know that Mr. Eckel did have a couple of appointments in those with ours, and they kind of got bumped down the line. This is why it had to be adjourned. My concern is, and speaking with counsel, this plea was taken with the agreement, is how I read it, that it's kind of contingent upon him participating in the sobriety court. So I would like the court to give this defendant the ability to try to get into one. He did follow through with the screening process. Any delay in that fashion was not on the defendant.
Okay, and I would just indicate, because people have said it different ways, I don't read the plea form that his plea was contingent upon that. What it was is the defendant pled and agreed to enter into the participate in sobriety court. So I don't think it would be a failure of the plea if he is not accepted. Okay, because I think if it were conditioned on that, that would be something different. But I don't read this as saying that he's just agreeing to go in. If they say no, then we've got to figure out something else to do. But all right. November 16th, December 6th, December 7th. What happened with your testing?
Your Honor, having spoken at length with Mr. Eckel regarding it, those 3 dates, if you notice the times specifically for those 3 out of his windows of the day total, they all occurred when Mr. Eckel was at work. Mr. Eckel does work within the engineering maintenance department of a hotel. The windows that he was just slightly delayed from submitting his test within occurred during times where he was engaged physically in his work. He did then go get his device immediately as soon as he was available. I think his tests are all within 10 to 15 or so minutes of that. We have spoken regarding the need to ensure that it is timely, not just submitted at the about the window. Fortunately, the tests all do come back as negative to verify that he was not consuming. We have spoken. He is going to make additional efforts. For the court's understanding too, I think it's important, as Mr. Eckel advised me, within where he works, there's not a locker or a safe storage area where he can keep his device free from access to others or tampering. So he does have to keep his device in his vehicle. So as soon as he completed an assignment he was working on, he'd go get it, albeit, as the court can see, about 10 or 15 minutes after the window closed.
Well, no, it's not 10 or 15 minutes. He was half an hour late.
Oh, I'm sorry.
Yeah, it's okay. Same point. I get it. All right. Just try to make sure you do it within those windows. Okay. The defendant is to seek an alternative sobriety court, either 14B or 15th, which may be available. You live in Ipsy, though, right? So maybe 14B might be a shot he could take.
Yeah, we were going to kind of explore both simultaneously. He does work in Ann Arbor, very close to the 15th District Court. So we were thinking that for review hearings, that might be even more accommodating with his schedule to ensure he can maintain employment and his obligations under the program. We were going to be speaking with both of the courts to help determine which is the most appropriate.
Okay. I'm just thinking as the new sobriety court came in that, well, anyway, I'm going to adjourn the defendant sentencing to January 28, 2026 at 12 p.m.
Thank you, Your Honor.
Okay. All right. Thank you. Court recalls the case People versus Reginald Sims.
Good morning, Your Honor. Justin Zaid appearing on behalf of Mr. Sims. Present standing to my right. State your name.
Reginald Sims.
Your Honor, date and time set for sentencing. We did have an opportunity to review the report. Accurate, no additions, corrections, deletions, if I just may allocate on my client's behalf.
Yeah, you may.
I know that based on your tone, I think you know what we need, what else we need to address.
Yeah.
If you would prefer that we address the bond violations first.
We might need to.
Okay.
Do that, but
certainly.
either way, whatever.
Well, we could start with that. That's fine. We were given the bond violation report. I did have an opportunity to review with Mr. Sims. We went one by one, Your Honor. I understand that the court might have concerns that it looks as though there's some type of pattern of disregard for this timing. And what we would submit to the court is that Mr. Sims has been on this device for about 4 months now, about 120 days, testing 3 times a day. I'm no mathematician, but over 360 tests, I believe. What you see in front of you, I believe, is the extent of the late tests. I believe that there are several late tests, some of which are right outside the window, some a bit delayed. Of course, there's no excuse, no justification for it, but to provide a little bit of context, Mr. Sims works overnights. He works at Ford. And so those tests primarily in the middle of the day would be when he's sleeping. He usually wakes up about 30 minutes before his 6 p.m. shift. And so he found himself having issues. We discussed how of course, we would have been more proactive, brought this issue up prior to getting this bond violation report so that we could find a schedule that would be more conducive with his work schedule, testing schedule, I meant. That being said, I don't think he's had a single positive test since he's been testing, whether before this, after this, at any point in time. I think he's demonstrated that he takes the court's orders extremely serious, albeit with some hiccups here, but nevertheless stands before you taking accountability for those. And is intent on demonstrating to the court, as he's already done for himself and his family, that he's going to abstain from alcohol.
When I look at this, though, I mean, it's a 3-hour window, and I'm unclear as to why he can't get himself in that window on numerous occasions. I've got 1, 2, 3, 4, 5, 6, 7, 8 missed windows. I mean, in some, he's up to an hour late in terms of testing.
5 in the morning. There's 2 tests. There's 6 to 9 and 12.
Right.
Yeah, so it's 2 months.
Yeah. So, Your Honor, he's working 6 p.m. to 5 in the morning. So basically, he gets home and it's testing windows about an hour later. So he's basically got to fight to stay awake. And then sometimes, again, it's no excuse, but he falls asleep. And so before that 6 a.m. window starts, he gets home at about 5:15, and he's basically got to fight it for 45 minutes to stay awake so that he could submit to it. Sometimes he misses that. And then the 12.
I get that, but there's only one of the tests that's a 6 a.m. test.
And then still
12 to 3 is the next one.
And then the next one's 12 to 3. And then he's saying he sleeps during that, gets up at around 5 p.m., gets ready for work and goes to work.
So I get that. So then why is he missing his 9 p.m. test? Which are 3 of these.
Your Honor, I know of one time I traveled and didn't get there to 12:07. Maybe it's something like a 12:04, 12:07. The other 2, I'm going to honestly say machine. I work, and I usually do that on my break. I'm at work at that during the 9 p.m. to midnight. So I've taken it every time, in my opinion. However, I did notice once or twice that it called for a late register. It said it did not, and I assumed or thought I did. So I do the thing all the time is, like I say, I work, I'm sleep during the 12 p.m. to 3, and I've missed out a few times because I just wake up 15, 20 minutes behind, so forth. But then I'm taking the test run. I don't drink.
I mean, I hate to do this, but because if I mean, the cold-hearted reality is that these are really violations of tether. It may say there's no distinction between that and drinking, but certainly the court could treat it that way. Is a scram tether going to work better for him? For the 30 days that he's going to be on Sunday?
What do you want to say?
If I'm just saying, I'm also a coach, so there have been a few times where I was either with the kids or the parents, and I'm always trying to break away, and so I can't do that. So there has been a few times where I'm in the midst of school administrative stuff because I got to blow up between the 12 to 3, and I try to get, and that you can see that they're just a few minutes behind. But I participate as a coach also at Belleville. I'm a coach and for 20 years, and so I am a part active as well as working, and I'm trying to make that time. There are only time.
Well, but you got to make the time.
I have been.
Otherwise, what's going to end up happening is I'm either going to have to incarcerate you, or I'm going to put a scram tether on you, which in dealing with the kids, and I see that is going to be probably more problematic in terms of what you'd have to explain to them.
Your Honor, when you look at the report, it recommends basically giving him an audition here. 30 days, get it right, or he has no excuse. I think that that's fair and appropriate. I've impressed upon Mr. Sims the importance of showing the court 30 days without a single violation. I think we would respectfully request the court adopt that, give him an opportunity to prove that he's going to be intent on getting it done.
Let me just say, there's a 3-hour window, and you just don't have to wait to the end of that 3 hours. You just have to do it within that 3-hour window. So in that respect, you really shouldn't be missing it. Okay, you just have to find time within that 3 hours to do that. All right, am I understood?
Understand.
Go ahead, Council, as to sentencing.
Well, I just briefly alluded to one of the points was that 30 days on the sober link. I think, again, based on everything we just discussed, I think that's fair and appropriate. We'd ask the court to adopt that. As it relates to the impact panel, we did.
This is where the temperature in the courtroom changes. Unlike earlier defendants, Mr. Sims isn't facing new criminal behavior. He's facing repeated noncompliance. And Judge Simpson makes something very clear. The court doesn't separate missed tests from drinking. A violation is a violation. The explanations stack up: work, sleep, coaching, family responsibilities. But the judge cuts straight through it with one brutal truth. A 3-hour testing window gives you options, not excuses. When missed windows pile up, credibility erodes. And then comes the moment that shifts everything, when the judge turns to the wife. That's not for show. That's the court assessing support systems and accountability beyond the defendant's words. So ask yourself, should personal responsibility outweigh life complications, or should the system adapt more to real-world schedules? Because this decision is about to land hard.
Tender proof of completion to probation, that has been completed as well. I understand that they are recommending in the alcohol education program. I think that given what I know about Mr. Sims, that would indicate that he can complete that program and move forward with this. Otherwise, we think that the report and recommendation is fair and appropriate. Ask the court to adopt it.
All right, sir, is there anything you want to say before I impose sentence?
Yes, Your Honor. Once again, I've been a standing citizen. Not only did the court have to give me a penalty or to say I had to do the breathalyzer, I did not drink. I have not drunk since the day after my accident. I want to take responsibility of that. Due to leadership, I'm part of the I lead kids around and coach and things like that. So I have to make an example for myself as well as others. So yeah, to tell her things like that, yeah, I'm a good citizen. So I don't want to be explaining to these kids like, to breathe. Like I said, I had to run out and do those things. I couldn't do that openly, but doing positive things, staying active, and I just work, stay active with the children, and spend time with my grandkids. So I follow your system. I believe. I apologize for the times that I was late. However, I was just late, based on activity and or sleep. But I respect the system. I apologize for being here, wasting everyone's time, and I'd like to move forward with you on good behalf.
Who's here with you?
My,
Who?
my missus.
Should say that louder.
I didn't.
You like whispered it, like.
Oh no, I didn't think
You didn't want anybody to know. I figured that was.
No,
who it was.
She's here.
Ma'am, you want him back?
Yes, but I'm tired of probably reminding.
Ah, see, I knew. That's why I wanted to talk to her, because she looked responsible. Like, you're talking about what a good and upstate citizen, and I'm not disputing that, but I think somebody helped you get there.
I sleep during that time period, Your Honor. So
Hold up.
12
hold
to
up,
3.
hold up. See, why are you talking? She just told me that she's trying to remind you. She's sick and tired of having to remind you.
Understandable.
Right?
Yes.
So, and all that really tells me is that at times, your husband is just not listening. She's trying to get you to do the right thing and follow all along. Am I right, ma'am? Yeah, okay. See, she's still trying to save you. All right. Listen to her.
I do.
She'll make sure that you'll get this done so you don't end up in trouble. You hear me?
Yes, sir.
I guess if she wants you back, I'm not going to stand in the way of that. Court does acknowledge this is not a serious misdemeanor as defined by statute. However, does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of alcohol. Tell them not to do that. Alcohol highway safety education program and abstinence from all intoxicants for a year. Therefore, the court will follow the recommendation of probation with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. It's therefore the sentence of the court. I'm going to place you on probation for a period of 12 months. In order, $855 fines and cost, $100 prosecution recovery cost, $100 police agency recovery cost, $360 probation oversight fees. When can you pay that?
Within 30 to 45 days, Ron, I'll put that.
Pardon?
30 to 45 days. Months.
You ask the person in charge when you could pay it? Or are you just making that up?
I just know I'll put
Ma'am, ma'am, when can he get this paid? In a month.
The next month's budget.
Well, no, you know what? You just,
The boss has spoken.
you need to stop talking. I just went to the brain trust. I got it. In a month. So by January 30th?
Yes.
Thank you, ma'am.
He blamed work and sleep. The judge cut through it. Fast, make the time, or you're going in.
I would imagine every time you started thinking on your own. There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete the Alcohol Highway Safety Education Program. You're to provide proof of the victim's impact panel attendance to probation. That has been completed. I'm going to continue the sober link for an additional 30 days in lieu of 5 days in jail. Order 93 days in jail suspended. Sir, one thing about me is I've got a very good memory. And your wife told me she's reminding you. So if I have a missed test, late test, anything like that, that means that you're not listening to her.
Today's docket made one thing unmistakably clear. Judge Simpson runs a courtroom where opportunity is earned and compliance is non-negotiable. Across multiple cases, We saw the same legal framework applied differently based on behavior, honesty, and follow-through. First-time offenders who demonstrated structure and accountability received probation focused on rehabilitation. Defendants who struggled with compliance were warned, directly, that the next step is incarceration. In Mr. Sims' case, the court balanced empathy with firmness, allowing continued probation but reinforcing strict expectations, sober monitoring, and a clear warning. The margin for error is gone. This wasn't about punishment. It was about preventing the next failure before it happens. And that's the broader takeaway here. Modern district courts aren't just sentencing. They're managing risk, behavior, and credibility in real time. Now we want to hear from you. Do you think the judge struck the right balance today? Would you have ruled differently? If you found this case as shocking and insightful as we did, make sure to hit that like button, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns you won't see anywhere else.